Morning, and go ahead and start the meeting. This is the public safety meeting. Today is July the 26th, and we are starting late at 9:58 a.m. And Mr. or Madam CLA, would you give me the first item?
Zine is here, ma'am.
Oh, yes, that's right. Mr. Zine is here and wants to be recognized.
On time, by the way.
All right, yes, he was on time, and we want to thank him for that. Thank you, Mr. Zine. All right, so...
For the record.
For the record. First item on the agenda.
John White, City Clerk. Item 1 is the Board of Police Commissioners report relative to a donation in the amount of $15,000 from the Harbor Area Boosters Association to support overtime for the Police Department's officers from the Harbor Area Juvenile Impact Program.
All right, is there staff here to make a report on that item? Go ahead, please.
Good morning. Peter DiCarlo from the Police Department. This is an annual donation from the boosters. It supports the youth program that's in the Harbor Area, the Juvenile Impact Program. The money is used primarily for the payment of police officer overtime for their participation in working with the youth.
All right, any questions, Mr. Zine?
Do they have any officers assigned full-time to this assignment?
That I don't know.
Is anyone here to answer that question?
I don't believe
Some
so.
divisions do have that, where they have officers assigned full-time to these youth programs within the divisions. We need to find that out, and if they do, are those officers then getting additional overtime, or are they putting additional officers in to have additional programs? And is there any impact program from the mayor's office in this adjoining area?
Not that I'm aware of.
Do you want to get an answer back on that before it goes to council, or you
Yes.
want to hold it in committee?
No, just, let's get an answer before it goes to committee. We need to get an
Why
answer.
don't you restate your questions for the record so they're very concise and clear, and then we'll make sure that the CLA assists us in getting answers on that before we vote on it in council.
So the number one question is, the officers that are assigned, is this additional overtime for those officers, or are there other officers that come in to supplement that program on overtime? And number two, are there any gang impact programs out of the mayor's office, out of the gang reduction in that particular section of Harbor Area where they have this particular juvenile impact program? Does this augment that program, or is it standalone? And I guess Harbor Division would have the answers to those. So we can have that
Before it comes to council.
before it comes back to council. And when's it scheduled for council?
No date's been set yet. It'll be next week.
Okay, so we need the answer by next week, so you have a week to get the answer.
Okay.
Okay. With
Thank you
that,
very much.
Thank you.
All right, we do not have a quorum, so
Recommendation to approve with those conditions.
we don't have a
A
quorum.
recommendation,
I know.
not an approval.
Okay, do you want to run the meeting?
I just want to help you out.
No, you're not helping me. Thank you. Okay, so, thank you very much, so.
What are we doing with it?
Hold on a second, okay, please.
Yes, ma'am. like to be-
What other items can we consent?
Items 7 and 8 can be moved forward unless either of you have questions. 7 is a CAO-CLA joint report relative to the UASI 2009 grant award. Item 8, City Attorney report and ordinance amending the LAMC for the recovery of the costs of implementing the above-ground storage tank program.
Okay. All right, that'll be fine. And we'll go back to 1 and then move that as a recommendation. And I'd like to take items 2, 3, and 4 together and continue them. I've been advised that the person who's filed the appeal is not present. Is that correct?
I don't know.
All right, on item 2, well, the name is blacked out, so I can't tell from the documents. They're the same person on items 2, 3, and 4.
There's a letter accompanying that. Did you see that letter?
Yeah, I have it right here. What? Is the individual who has filed an appeal on items 2, 3, and 4 present? All right, why don't we continue those items? Okay.
Is the police department here on that matter, 2, 3, and 4? The question is, this individual,
You know what?
my question is,
You can go ahead and run the meeting.
I just want to ask a question on this particular matter. Pardon me?
It says, form of respect.
Okay, no, I want to ask a question on this.
All right, go ahead, but don't do it again, okay?
The question is to the police department, if this individual has
Do you want to know whether somebody's present from LAPD on this item?
There is somebody in person from LAPD on this.
Is there someone present on this item? Would you mind coming up for and answering Mr. Zine's question?
My goodness.
The question I have is, in the past on this committee, there have been individuals who have submitted information on graffiti. They haven't submitted the paperwork in a timely manner. They submit the paperwork late and then request the reward. My question is if this individual has done that before or not.
On the 3 that were denied, it is because he was late with his paperwork, but he has applied 3 other times in a timely manner and was awarded.
Okay, so he's never applied late until this particular time, but he has applied before
Yes, he has, sir.
in a timely manner.
Correct.
Okay, that's fine. Thank you.
I would like to afford that person the opportunity to speak on the record to make a case as to whether or not they applied in a timely way this time, so we're going to go ahead and continue these items. So that's 2, 3, and 4 that will continue.
All right.
And that takes us up to item 5.
Item 5, motion Smith-Koretz, instructing the Department of Animal Services to report with recommendations for a plan to implement the provisions of AB 2689 to improve rabies reporting requirements and to increase the number of dog licenses, including options for the participation of veterinarians in the rabies registration process.
All right, we have staff on item 5. You can come on up, please. Identify yourself for the record, if you would.
Good morning. My name is Kathy Davis. I'm with the Department of LA Animal Services.
John Forland, also with the Department of Animal Services.
All right, go ahead.
Okay.
And 8.
Go ahead. Yeah.
Good morning. With regard to AB 2689, let me back up and give you a brief history on the process that prompted, obviously, our pursuit of AB 2689. In May of 2009, we launched an online dog licensing program. That program was obviously to assist us in expediting and making more efficient the process of being able to obtain a dog license. What we found out in the process is obviously that the state law prohibits us from accepting a rabies certificate unless there's a wet signature on it. And that obviously stalls the process of being able to then issue them online because we wouldn't have that wet signature on the rabies certificate. Knowing that, we then reviewed the state law requirements and went about the process of trying to obviously resolve that, and were successful. We now need obviously a corresponding amendment to our local ordinance in order to be able to accept those changes that the state has made to be able to do online licensing for all of our dogs. Currently, the program only allows us to do licensing for those dogs that are in midstream for a rabies inoculation certificate. In other words, if they had a 3-year inoculation certificate, then they'd be able to go online and renew their dog license. We obviously foresee expanding that online process. We issue annually about 112 to 116,000 dog licenses, so being able to use the online process would help us and relieve our staff of obviously the huge volume of licenses that come in, and we foresee that obviously we can do that. We can expand the current online system that we have to accomplish those particular situations, to be able to verify the rabies compliance through an online system. We also will need to be adding some server capacity to meet that hoped-for demand. There's about a $3,000 or $5,000 cost to do so, but we feel we can absorb that in our current budget. We're also in the process of developing a nightly automated upload onto our Chameleon system from the online system. I would like to commend our in-house IT staff because we've been doing all of that in-house rather than going outside, which is obviously saving us some money. Finally, we also expect and will need some promotion, some marketing done with regard to that new online system once an ordinance has passed to support that. We've contacted our good partners, Found Animal Foundation, and we've already had meetings with them to be able to talk about the kinds of promotional information that should be out there that will help us in obviously bringing to the public the idea of doing their dog licensing online. We expect our new online system will be expanded and ready to go probably towards the middle or end of September, when we hope that obviously the ordinance will also be ready to go, that will enable us to be able to do dog licensing online. The ordinance is being worked on by our city attorney's office. As you know, there was an item that came before you on June 28th to help support that. So we also have Dov LaSalle, our legal counsel here from the city attorney's office, if you have questions with regard to that enabling legislation.
No.
I'm good, yeah.
Okay. Any cases of rabies that we're aware of in the city in recent times?
Not within the city that I'm aware of at this particular moment.
And when we do have cases, it tends to come from like wild animals, usually
Exactly.
traced to squirrel or something.
Raccoons primarily. We do have alerts that have been issued by the county health department with regard to raccoons, so we're watching those wildlife that come in very closely.
So when it comes to the monitoring and control of rabies, we're pretty much in good standing so far?
Councilmember, I believe that we are. However, there's always the possibility when people get into a relaxed state of security on rabies that's exactly when it will come back through. Clearly, in other parts of the nation, there are problems with rabies that are developing because we've taken a rather relaxed stance with regard to rabies inoculations. So getting this kind of a program up and running to reinforce the fact that rabies inoculations are very important, and obviously licensing is the check on rabies inoculations, I think is an important piece of legislation that we need to promote and pass.
And if someone's pet dog gets rabies, what is the consequence, or what's the result of that if that particular animal actually contracted rabies?
Largely, it's euthanasia for the dog, or a very, very painful death.
Okay. Anything else?
No, I'm good.
Okay. All right. So we'll note and file the motion. We don't have any more public comments on this one. Okay. Thank you very much.
Thank you.
We'll go to item number 6.
Item 6, City Attorney Report and Ordinance, amending the LEMC to update the definition of very low-income person and disabled person for purposes of fee waivers and free dog licenses, and requiring that a dog be spayed or neutered prior to the owner being issued a free license based on very low income or disability eligibility.
Okay. Is anybody here from the department? Item number 6.
Council members, Kathy Davis from LA Animal Services again.
John Forland for whichever. Good morning.
Thank you.
Council members, with respect to this ordinance, as you may know, we make certain allowances in the ordinance to provide our low-income and disabled folks with special benefits with regard to dog licensing and other benefits within the ordinance. The ordinance currently allows us to come back in and ask for a change to obviously provide a different income level. The current ordinance states that we use the two-person family income, very low-income guideline of $33,150. That's regardless of the number of people in the family. So in other words, if you have 4 or 6 or 7 people in your family, we still cling to that $33,150 as the guideline for verifying somebody's low income. That obviously isn't a very good way of doing things, and other departments such as DWP observe the full federal guideline for the income limits, which allows for a family of 4, for instance, to be $41,400. We think that that is the proper and the right thing to do, and are asking, obviously, for your blessing to allow us to use the guideline for the number of people currently in that household in order to verify income.
Okay. So basically, adopting a method that's more consistent with how other departments determine low income.
Exactly.
Okay. Thank you. Any questions?
No, I'm good.
Okay. All right. Yeah, I'm sure that will, in fact, encourage more individuals to do the right thing and make sure that they follow through with their requirements rather than being afraid of the fees. Is there anybody here to speak on number 6? We have a bunch of upside-down 6 cards, but not
That
number
means
6.
9.
Okay, nobody here for public comment on number 6. Thank you very much. We'll close public comment on number 6. With that, the committee approves the ordinance. Now number 7?
That got,
Oh,
so 7 was.
What did we do?
Councilman, 7 and 8 have already been approved. Did you want to add yourself to those items, Mr. Cardenas?
yeah, okay, let's,
Go back.
which items were on consent?
7, 8, and the committee approved item 1 and continued item 2, 3, and 4.
Okay, so with that, we'll have a full vote on items 7, 8, and 1. Those items are approved.
Very good, sir. Item 9, Board of Fire Commissioners report relative to the Fire Department's 2009 brush clearance assessment hearings report and proposed appeal decision and recommendations.
We'll hear from the department first, and we have a handful of public comment cards. People who have filled out public comment cards will have 2 minutes apiece to speak, and I will call you up by your name and the order in which the cards are on my desk. Please.
Good morning. My name is Robert Nye. I'm the captain, commander in charge of the brush clearance unit for the Los Angeles Fire Department. Fire Department inspects over 130,000 individual parcels that are located in the very high fire hazard severity zone. Properties that are found in noncompliance when we do this inspection sweep in the month of May are issued a notice of noncompliance. The property owner is given an opportunity to abate the hazard themselves within 2 weeks of a due date that is posted on their notice. If the property owner fails or refuses to comply, the fire department will then go forward and take action and abate that hazard and will bill the property owner for the cost of the clearance plus an administrative fee. The fire department cleared approximately 1,100 properties in 2009, and those appeals, property owners who chose to appeal those charges were given a hearing date to come in and appeal that before a hearing officer. The hearing officer was given the opportunity to hear and weigh either in favor of the department or in favor of the appellant and could reduce and or modify those charges. Those charges then will be moved forward to the Board of Fire Commissioners for approval, and their report will then be forwarded over here to full council at Public Safety and for approval and to be forwarded over to the tax rolls.
Okay. And throughout this process, what is charged to the owner of the property for the first inspection as you described?
That's a new fee for this year. That's separate. This was not imposed back in 2009. These brush charges...
In 2009, the first inspection did not incur a cost on the actual property owner?
That's correct.
Okay, and what would it be in the future? Should we enact that?
For 2010, this is the first year, initial inspection fee was assessed at $13.
So $13 starting in 2010.
Correct.
Okay. And then when it comes to the second inspection, what is the charge to the property owner?
A property owner who fails to comply by their due date is then charged a non-compliance fee of
How much?
$300.
$300?
Yes.
And then on the third inspection?
For the third inspection, it would be when we go forth with abating the hazard that is still present, and there's the cost of the clearance that we hire a contractor for. That process is through a bidding process to approved qualified brush clearance contractors. So the cost of the clearance plus an administrative fee for the processing of the bidding process, hiring of the hearing officers, repeated visits back and forth to the property to make sure the property is in compliance. There's a $1,026 administrative fee assessed to that. The appeal that is before this committee this morning is for the brush clearance assessments, not the non-compliance.
Okay. Now, should a fire occur on say one of these said properties that goes through this inspection process when it comes to brush clearance, and if a fire were to occur, how much do we bill the owners?
Currently, there's no mechanism in place where we bill an owner who already has a violation in place. We will look back at that particular property and see how much of a contributing factor it was to the spread of the fire, but there is no mechanism in place where we charge the property owner. I've been to the brush clearance unit for 5 years now, and I haven't seen that take place yet.
So by and large, the custom and practice of the city of Los Angeles, should something occur and perhaps an owner was negligent in following through with that brush clearance, we would send our people out there, put out the fire, save lives, whatever we have to do, take care of business.
Correct.
And then, by and large, the custom and practice is not to send a fee or try to recoup some of those costs for putting out that fire.
To my knowledge, I haven't seen that
I
happen.
think you're correct. I haven't heard of one either. Have you?
No, I haven't.
No, I haven't. Okay. So what we're talking about here is a process of preventative, correct? This is all a process to prevent. And in order to prevent these kinds of fires or these kinds of occurrences, we've created this mechanism, this series of inspections and requirements and compliance in order for us to hopefully have less fires.
That's correct.
Okay.
Yes.
Anything else, sir?
No, that's it.
Okay. Any questions for me?
No, my book here.
Okay. Got the book. Okay, thank you very much. At this time, we will call members of the public up who have filled out cards. We'll start with Bob Tanabe.
Can you cite what parcel it is, what page or something?
Ton.
You're welcome to turn in any statements to the clerk, to my left. And if you could take a few seconds to identify which property you're referring to, if you're referring to a particular parcel.
Yes, my name is Bob Tanabe. I'm referring to 9643 Green Verdugo Drive in the city of Sunland.
May I interrupt? Is there an APN number? There's an APN,
Oh,
APN number.
Yeah,
That's-
the assessor's ID number is 254-500-2003.
That's Tanabe?
Yes.
Okay. Okay, got it.
Yes, basically, I'm here because I was one of these homeowners that was caught totally out of, with surprise in this new inspection procedure that the fire department imposed just last year. Apparently, I had been in compliance all previous years with the brush clearance requirement and was never cited. I was never told that any existing conditions were in violation until just the year 2009. And at that time, I received a notice. I did a number of remedial work in terms of cutting back the additional brush, and a notice was posted on my, apparently my tenant store. This property is a two-building unit that I own. It's a rental property, and I never received any notification that it was posted, and I've always received notification from the fire department of any type of action that they would take. And I think it's unfair for them to just post instead of giving me some kind of formal written notice, especially when they intend to impose such exorbitant fees for this process. I tried to comply. The inspector was the same inspector that passed it for many years prior to that, and she also noticed that the considerable additional work that I had done, yet I never received any kind of written notice sent to my home, which is how the normal communication is. And so I'm objecting to the fees.
Mr. Tanabe, so you live at the parcel that you're talking about?
No, I don't live there. That's a rental property.
Okay.
I live at an Ocean View address, and I've always received notification from the fire department, written notification at that address.
Okay, so you're saying that over the years, you've always received it at that address?
Always.
Did you
I've always
receive it
complied.
at that address this time?
Pardon me?
During this particular process in question, did you receive it at the Ocean
No.
address?
She said she posted some kind of red tag on the door.
So perhaps what you're identifying is when you were in compliance, the notices were sent to the owner's property, not the property in question. But when, for some reason, it was considered to be out of compliance, it appeared that they gave notice to the actual property itself.
Right, they gave notice to the tenants,
Okay.
not
So-
to me.
So that's one of your contentions?
That is, I just want some consistency, at least give me an opportunity to meet with the inspector and go over what she objects to before they start assessing me these
And when was the
fines.
first time that, on this particular instance, when was the first time that you interacted with the city on this particular instance, on the non-compliance process?
With the city or with the fire department?
They're part of the city.
Okay. Well, they did send me a notice, original notice that, I have to get brush clearance. I did that. They came out with a second inspection and said that I still needed to cut back some more, which I did. And then, after that, I never received anything else, and then the inspector said, had posted at the hearing, told the hearing officer that she had posted some kind of red tag notifying that it was not in compliance. And so I had no idea because...
And how were they notifying you the time that you cleared the brush and then cleared the brush again?
They were sending me notices.
At the Ocean
At that
address?
Ocean View property.
Okay.
I get these notices that's why I know that it was, it didn't pass the first time, because they would send me the notices saying that, it has not passed the inspection, more needs to be done. And that's when I cut virtually the whole hillside down. And I have to balance my position there because it's a hillside behind my lot. And if I cut too much and then the rains come, then I have a landslide condition. So, I thought I had complied with it because I never received any further notice once I did my second cutting. And the inspector noticed it because I left it's a huge driveway, and virtually half of it was all covered with branches, with cuttings and everything. She noticed that. She even confirms that on her letter in her meeting at that hearing, that she noticed that a lot of work was done.
Okay.
But I never received any subsequent notice after that saying that I needed to do more. And I didn't know what else I could do because my property line only goes so far back.
Okay, thank you very much.
But one other thing, the fire inspector said that the administration fee is under $1,026, but I was assessed $1,112. Plus $300 for another inspection that they did.
Yeah, the $300 is prior to the $1,026.
So I'd like to get a clarification, which is the applicable fee.
Okay.
Okay. The appellant, Mr. Tanabe, he's located on page 131 of your blue book. I don't know if you've located that already. The subject property is correct. It's at 9643 Green Verdugo Drive. The property was inspected actually on May the 11th in 2009. Notices of noncompliance were mailed out to the address on Ocean View Boulevard. They were not returned, so it had assumed that Mr. Tanabe was properly served. A reinspection occurred on the property on October the 26th of 2009, and more work still needed to be done. It was still not in compliance, and a second notice of noncompliance was issued to Mr. Tanabe at the address on Ocean View. The property then was subsequently posted on October the 26th of 2009, indicating that the property still is in noncompliance. Property owners are served in two ways. They are served by either the letter, by both ways. The notice is going actually to the property address that's on record with the county assessor's office, and we actually physically post the property where the hazard exists in two ways. The property then was subsequently contracted by the city contractor and completed on January the 4th of 2010. Mr. Tanabe had an opportunity to review those photos at the hearing. The hearing officer weighed in favor of the fire department because it followed procedure. The appellant was giving due process. He had received all the notices of noncompliance to his address. Although Mr. Tanabe did some work, but the property still remained in noncompliance, and that's why he did not get a cleared by owner record, and therefore he was assessed the charges. The charge of the cost of clearance for that property was $300. The administrative fee is the fee that's attached to that cost was $1,112, which brought his total assessment to $1,412.
Well, Mr. Tanabe asked the question, might as well get this out of the way early in the first public comment, is the administrative fee $1,026 or is it $1,112?
Yeah, the administrative fee changes, and at the time that Mr. Tanabe was assessed, at that time it was $1,112.
Okay.
It did go up to $1,026. I mean, went down to $1,026.
Okay. All right. So that's why it's not $1,026. The fee at one time perhaps in 2008.
When did that go into effect? When did they lower the fees?
I can get the exact date for you, but I know it did happen in 2009.
Okay.
Then, as we look throughout our book, there will be some dates that will say it will be 1,026, and then there will be some others that will be in here that will reflect the 1,112.
May I also add something? He said that the first notice went out in May, and then the second notice came out in October. Now, that's a considerable amount of time, so obviously a lot more brush activity had occurred. And so I think it's simply unfair for them to stretch out these inspections to allow more brush to develop so that they can come back and say that it's non-compliant. It's, you
But
know,
with all due respect, Mr. Tanabe, whether they come out in May, June, July, August, September, October, January, February, March, still is the property owner's responsibility to make sure that the clearance is safe.
I understand that, and I got the notice in May, and I took measures to correct that, and if I'm, 6 months later, I don't get any notice that something is wrong, then I'm under the assumption that, yes, it's in compliance. So, it's not a consistent process that they have in terms of notifying and serving notice on homeowners for, this brush clearance.
Okay. Question of the fire department?
Yes.
Regardless of when the department physically goes out to a particular parcel to inspect, is it incumbent upon the property owner to make sure that it's within compliance year-round, regardless of whether or not the notice is initiated by the city fire department?
Yes, that's correct. It's their responsibility. The brush clearance is a year-round responsibility. We can have brush fires.
It just so
any time
happens
of
that the
year.
fire department does things in May and then in October or what have you, but regardless, 365 days out of the year, it's still incumbent upon the property owner to make sure that it's in compliance.
That's correct. There's over 100,000 inspections that we have to get through, and sometimes there is a delay before we get to them by their due date.
Sure.
And that's what happens.
But I just want to clarify the law and the responsibility of
That's
parcel owners.
Yes, sir.
Okay. One more question to you, Mr. Tanabe. Is your property occupied by tenants?
Yes.
Did the tenants ever claim to you that the notice was not posted?
Well, I don't know which unit they posted the notice, but the tenant claimed that they never saw anything. Now, I don't know what to believe. That it might have been that there's very, very severe winds there. It might have been that the winds blew.
How many units do you have on the
It's 2 units, 2 houses on the lot.
Okay.
And so they never received it as far as, I asked both tenants, they never saw anything, so I never got anything. And as I said, the mode of communication is generally between myself and the fire department has always been that they sent such notices to my home address. And that's how I've always received that communication. That's how I've always acted. And I've always been in compliance previous to that. And I've owned the property over 10 years.
Okay. Thank you very much. Question of the fire department. You did, in fact, concur with Mr. Tanabe said that, for example, in this particular case, in the October activity of communication, that the notice is sent in 2 ways. One, to the property in question address, and also posted at the property in question, correct?
Correct.
You did not claim or say that in this particular case that it is custom and practice for the department to have also sent it to the Ocean View address?
No, we send it to the Ocean View address.
Okay, so
I'm sorry.
they notice in 3 ways?
No, it's
Custom and
in
practice?
2 ways. Let me clarify.
Okay.
It's 2 ways. We send it to the address on record by the county
The
assessor.
mailing address on record, because can be more than
The
one
mailing
address on record.
address. Correct. We send it to the mailing address of the legal owner on record of the property, according to the county assessor's office. We also physically post the property with a posting of a hazard to abate
Okay.
on the property where the hazard exists.
Okay. So in this particular case, it appears that Mr. Tanabe is telling us that the Ocean View address did not receive the notice that went out on or about October.
October 26th. Yes.
Okay.
He did
All right.
receive the first 2, though.
Yes, but not in May, et cetera, but not the October. Okay. Any questions on this? Mhm. Okay. The next one is Delfina Gomez.
To make a finding. To make a finding.
On individual? I thought we both, you can do it as a whole. So
You do each one.
decide which one.
No, we could do that. Normally we
Un momento, 1 minute. The procedure, if we have an exception to the findings according to the department, do we have to handle them as the individual comes up and speaks on them, or can we handle them as a whole and then pull out the ones that we want to change?
In the past, the decisions have been made after each speaker has presented his or her case. But you certainly can wait until the end of the entire meeting to make your decision.
Okay, all right. Thank you for the clarity. So we have the option, members of the committee, we can make our own findings and change the recommendations of the department after each one of the individuals speaks, or we could come back to them and we can individually decide which ones we want to pull, and then we can make our announcements as to what our motion would be on each particular property that was spoken to by members of the public. Is there any preference from anybody on the committee?
For the convenience of the folks who are contesting, for them to wait while we go through all of them, they're concerned about their particular parcel, and I'm sure they want to move on with their activities, but to wait till the end, it would inconvenience them. I'd prefer if we just make the decisions and then move along the different ones that we have to review and make individual decisions. I think it's fresh at that particular time versus holding them until the end and then inconveniencing the folks that have to sit here. Sometimes these things take 2 hours to review the cases. So I'd prefer to do it all at once, individual decisions, individual cases.
Okay, thank you very much. Recommendation by Member Zion of this committee. Chairman will concur. We will handle them as individual votes as to whether or not to concur with the department, or if any particular committee member wants to make a recommendation that differs from the department recommendation. You have the opportunity to do so. Yes.
Two couple things about this case that disturb me. One, that it's only a 2-unit building, and I know it's very windy up there in that area, and
Yes, it is.
yeah, and you know, I don't know how the notice was affixed to the property, and tenants are not always alert to notices being posted, and nor do I think it's necessarily the tenant's obligation to let the landlord know. And if the department had the individual's home address on file and had pattern and practice of sending notices in the past to the home address, I'm not sure why that wasn't done in this case. So this one, it makes me, I would recommend against, I would vote against the department recommendation.
Okay. And then as far as the cost of clearance, administrative fee, the total assessment as a whole?
Was that a question?
Yeah, it's a question to you.
Well, I don't know how they work it out. I don't know procedurally if I vote against the department recommendation, I guess that means he would have to be provided another opportunity to comply. I guess that's how it works. Am I right? Somebody tell me. No?
Department?
We can recommend to waive entirely, reduce and/or modify the current total assessment. The city paid $300 to abate his hazard.
Well, I do believe the city should recoup its outlay. I do
Yes,
believe
ma'am.
in that. Now, I don't know if you can make a decision on that today, whether to review, modify, or what were the choices? Modify?
Reduce, modify, or waive the entire assessment.
Yeah, I do. Whatever outlay the city incurred, I think the city should at least recoup that.
Okay.
So I guess that might fall in the category of modification or reduction.
Yes, the administrative fee of $1,112.
Anything you'd like to add to that, Mr. Zine?
The department states that 3 notices were mailed out, and while the property was posted, Mr. Tanabe states that he didn't receive that 3rd notification, but the department did mail out 3 notifications to the La Cañada address,
To the Ocean View address,
in
yes.
addition to the posting.
Correct.
And the department notify them when it's in compliance, or if they do satisfy under a notice, how do they know that they're
Signed off.
their clearance, how do they know that it's been cleared?
They're issued a notice, cleared by owner record, which is an F-1307
Well,
form,
they are issued a notice that it has been cleared.
that it has been cleared. No,
by whatever means they do, so no notice was sent to them
that it was cleared, no.
that it was cleared, and the, Mr. Tanabe has had this property for how long a period of time?
I'm not sure, but he said he had it for several
Tanabe.
years.
So in the past, Mr. Tanabe has received a clearance that the property was properly cleared, that the vegetation was properly removed to the proper standard. So there's a record of that in the past. This particular time, he did not get that notice that it was cleared.
Correct.
So I would side with the department, since there's a history that a final notice is given when the property is cleared to the satisfaction of the fire inspector. So I would side with the department for the $1,412 for the cost of clearance, also the administrative fee. I think it's appropriate, since there's a history with that particular parcel that Mr. Tanabe owns.
Question of the department, when it comes to the notice, for example, in this particular case, I'll describe it as the October notice that was mailed to the Ocean View property.
Correct.
What record of that notice does the department keep? Is it done with certified? Is it just mailed out?
That was first-class mail.
First class mail?
Yeah, just first-class mail, yes.
Okay, so there's not a signature receipt process?
No, no, sir.
Okay. So that is the method that we have today. Unfortunately, for the owner, we do not, the city does not exercise, when I say the city, I say the city department of, fire department, it's part of the city. They do not have a signature receipt method in place, so I don't understand why the fire department would go about their business to violate their own process on the third notice that's mailed out, in this case, to the Ocean View property. So I personally don't understand why there's a disconnect between the owner and the department having communicated for that third time. So being that there's, I have no way of knowing that there's evidence that it was or was not mailed out, I see no reason why the department would purposefully not comply with their own procedures. I have to assume that the notice went out. For some reason, it wasn't seen. The tenants aren't here to tell me that they never, ever, ever saw a posting. Obviously, the tenants didn't tell the owner that there was no posting, or that there was a posting or not. So I have no reason to believe that the department violated their own process. So I'll concur with Councilmember Zine on the whole assessment of $1,412. So with that, yeah, we'll vote on your motion.
Okay.
It was the motion of Councilmember Perry that your motion was to charge the $300 only?
Yeah.
Okay, the $300 only. Is that a substitute motion, Mr. Zine? To substitute motion to charge the whole fee and concur with the department?
No, I do not second that. So
No. Her original motion.
her original motion is to the cost of the clearance only.
And your comments were
To pay.
that you concur with the department on the $1,412.
$1,412, correct.
Would you like your comments to be a motion?
I'll make a
Concur
motion.
with the department as a substitute motion to Ms. Perry's?
I will do that, make a substitute motion that we support
Okay.
the total.
So therefore, we'll
assessment of
vote on the
$1,412.
substitute motion first.
Did you record me as a no vote?
Correct. Okay, substitute motion is voted on. Zion Cardenas vote for the substitute motion. Ms. Perry votes against the substitute motion as a no. Okay, that passes. The department has been confirmed, and the property is assessed $1,412. Okay. Señora?
Sí, mire,
The
mi
page,
nombre es Delfina
Yep.
Gómez.
Un momento.
page on this?
Your APN
Okay.
number on the property? Yes.
It's 5216.
I'm sorry, hold on, the door was closing. Hold on. Okay.
It's 5216009036.
¿Cómo se llama?
And property owner is Gomez?
Yeah. Delfina?
Delfina?
Delfina? Sí. Okay.
The captain.
5216.
Captain, which page would it be?
I'm getting it.
Un moment.
5216?
5216009036. The book's organized by assessor.
5216009036, page 268, Del Rena Gomez. Right?
¿Puede comenzar, señora?
Ah,
You can start.
sí, mire, yo vengo porque quiero saber por qué me están a mí cobrando este cobro de 1,826. Si era del dueño anterior, ¿por qué me lo pasaron a...?
Okay, now go, you want to interpret for her?
Oh yeah, she's just claiming that why do they have to charge her the 1,826 when she didn't have the property on 2009. She already bought the property on September of last year.
Okay. ¿Sigue?
Sí. Supuestamente que nosotros cuando agarramos la casa no tenía, pues nos dijeron que no tenía ninguna deuda de nada y después empezaron a llegar unos cobros del dueño anterior a mi casa y nosotros los regresábamos y los volvían a mandar y mi esposo habló que por qué llegaban ahí esos cobros a la casa y que era del dueño anterior.
Okay.
Oh, well, she's saying that
Que del dueño anterior que llegaban los cobros de la casa.
because she was paying some some fees from the other owner with the other owner's name, and we call back and they will tell us that
que llegaban acá a la casa y queremos saber por qué.
¿Con
ahora
quién hablaron,
no.
señora? Who did you talk to?
Mi esposo fue el que habló con
Sí,
uno.
pero habló del departamento de bomberos o al número en el documento?
Sí,
Okay. So she basically called back the number on the documents asking, why are you charging us for something that has the previous owner's name on it for previous owner's activities?
Mr.
Sigue.
Cardenas, if we could also get the name of the
Interpret.
young lady who's doing the interpreting for the record.
What's her name?
Wendy Jimenez.
Wendy Jimenez. ¿Sigue, señora?
y pues mi esposo habló y le dijeron que él tenía que arreglar esto, que porque si no nos lo iban a pasar a la cuenta de nosotros. Y dijimos que pues nosotros cuando firmamos los papeles de escro, nos dijeron que no tenía, pues nosotros dijimos que si no tenía ninguna deuda de nada, y nos dijeron que no.
Y cerraron el escrow en septiembre del 2009,
Ajá.
¿verdad?
Sí.
Okay, so you closed escrow on September of 2009.
Ajá. Y ahora resulta que ya me lo mandan a mi cuenta. Y
Ujú.
quiero saber por qué.
Okay. So her basic protest is, this is a charge from the previous owners, and they closed escrow in September of 2009. It appears on this document, we can confirm with the department, that the work was completed by July 21st, 2009?
Yes,
That's correct?
yes.
So, in this particular case, what is the process that we file these documents so that when it comes to clearing title on a transfer of sale, which occurred in this case, what process does the fire department utilize to make sure that the charges are incurred ongoing rather than at a later date?
Well, what happens is once we submit the second notice of noncompliance, that means that the property owner did not clear it by their due date. We submit what's called a 9A report, which means it's a pending lien is going to be subject to the property if it's not cleared up. The property was never cleared up, and the pending lien then turned to a full lien against the property for the assessed amount of the charges that were applied. Ms. Gomez obviously purchased the property with those liens already attached. The hearing officer's report indicates that they did not appear before the hearing but submitted the escrow papers, and that the escrow papers did reveal that there was a tax lien and a 9A notice that was therefore attached to the property, and that's where the lien came from. When she purchased it, she purchased that lien as well.
Señora, lo que explicó señor, es que cuando ustedes cerraron escrow, que hay evidencia que un reporte que se llama 9A, ese documento notifica que los cargos de $1,826 sí fueron parte de la propiedad y que en ese momento, cuando ustedes firmaron esos documentos para cerrar el escrow, ya recibieron el aviso que esto es parte de la propiedad.
A nosotros no nos dijeron, no nos explicaron así.
Un momento. I just explained to her what he said.
Yeah,
Now, did the department concur by getting a document of that escrow document, or just confirm with the escrow company or the title company that the documents were clear? Excuse me, that the 9A report was part of their escrow documents?
Yeah, that was what was submitted to the hearing officer, and that's what she put in her report, or he put in his report. But the fire department keeps a record of all 9A reports that it posts, and that one was posted on this property. She has other avenues. We inform property, this happens all the time, we inform property owners that if they've got title insurance, that's exactly what it's for, is that do a proper title search on a property before purchasing it. And they can go through those avenues to recoup these funds to pay for these charges. But these charges get assessed not to the property owner, but to the property
To the
itself.
property, correct. All right. The only thing that we could do right now to verify, because it was reported to the hearing officer that the escrow documents did in fact have the 9A report, but nothing's been said this morning from anybody saying that someone can actually personally concur that document was part of their escrow documents. So I guess the only thing we can do right now is try to get a copy of not so much the escrow document, but the title policy.
Yeah.
Because the title policy in and of itself is where that document would have been notified to the previous owner and the buyer. Did you have something you'd like to add,
This is
sir?
Inspector Paul Terrace. He is the inspector for the area, and he was present at her particular hearing when they were reviewing her information.
Okay, Inspector, what can you explain to us?
When Ms. Gomez came to the hearing, she had the papers, and apparently she bought this cash through a private party. She did not go through escrow. And in her paperwork, she agreed that she would pay all pending liens and taxes. And I believe she paid $10,000 for the piece of property, and they did not go through escrow and therefore did not do a title search.
Okay, thank you very much. That sheds a lot of light. Señora, cuando ustedes compraron la propiedad, ¿ustedes lo compraron con un banco ayudándoles con el dinero o lo compraron con dinero en efectivo de ustedes? ¿Solamente el dinero de ustedes o incorporaron un banco en el proceso, recibieron una préstamo de un banco cuando compraron la propiedad? Déjame explicar en inglés. I'm asking her if when she purchased the property, did they incur a bank? Did they get a loan with the property, or was it basically their money, in effect, their cash, their own money, without a bank loan when they purchased the property? Señora?
Sí, de un banco. Ramón,
No si sacaron el dinero del banco, pero si
Sí, pues,
sacaron
bueno,
un préstamo encima de la propiedad cuando lo compraron.
sí.
Si está aquí el esposo y quiere ayudar, por favor, ayúdenos. Si no, puede ser que les va a ir mal. ¿Ok? Por favor.
Es que como los dos hicimos, pues,
Can you let him sit down? Thank you. ¿Su nombre, señor?
Ramón Jiménez.
Ramón Jiménez.
Sí.
Ok. Cuando compraron la propiedad, ¿la compraron con dinero de ustedes o la compraron con dinero, con ayuda del banco, con un préstamo sobre la propiedad?
Sí, agarramos un préstamo en el banco para agarrar la propiedad. Nosotros agarramos el plan del FHA y agarramos ese plan del FHA que nos ayudaron con pues el programa pero agarramos el préstamo en el banco y lo que pagamos de impuestos y eso lo pusimos en el dinero de nosotros.
Mhm.
Pero sí agarramos el préstamo del banco para comprar la propiedad.
So basically, he's saying that they did use a loan from a bank and they used the FHA type loan for the property. Sir, that's very different than what somebody explained in the hearing that you were at.
Yes, sir.
Because, and the reason why I asked if a bank was involved, you can buy property cash all you want without having a title search and having a clear title. That's your choice. Not smart. But when a bank's involved, even though some banks aren't all that smart, they always get a title clearance. So unless what happened was there was a personal loan that they in effect utilized to buy the property, then a title search would have not been done. So out of fairness, what we should do is, can we bifurcate these items and put a specific case over, or do we have to announce that we will look into it as we go into
In the past, when additional information was needed, the item was held over for a week, and the parties involved, either the property owner or fire department, would come back and report back to you next week.
just that one case item?
Well, and then after that item was resolved, you'd move the entire package to council.
So basically, we'll keep the whole package?
Yes.
Okay, all right. Okay, so, do we have a mechanism within the fire department to find out who the title carrier was so that we can get the documents directly from them or what have you? Because what happens is, in all fairness, not that somebody would do this, but if we ask somebody for documents and they say we don't have them, or they give us an incomplete document, then we're really not getting down to the bottom of it. Yet the title insurance company, they have no axe to grind. As long as they can release that particular title report that was issued on that day, we really don't know what the truth was as to what was in those documents. Is there any mechanism with the department that we can, unless we have some kind of subpoena power to ask the escrow company or?
The only documentation that the fire department keeps on record is the...
No, I'm not saying what you have already. For the purposes of finalizing our decision.
Correct.
We would want to look and see, did the documents make these buyers aware that that lien existed, and therefore, when they signed tough cookies, now they assume that liability and responsibility.
Right, right.
They're claiming that they were not aware when they closed escrow.
Correct.
Which again is not your problem, but at the same time, if they were aware, then they have to pay. Now, whether they had somebody explaining the documents and they didn't explain that part and they signed it, that's their problem.
Right, right.
They were made aware by the actual documents being before them. Now, whether they read them or they understood them, or if somebody explained it or not, again, that's on them.
Yeah.
Mr. Cardenas,
Yes.
wouldn't their issue be with the title company if, in fact, there was a title company?
Yeah.
Would have to be. Currently, we don't have anything.
But they came to this body saying that they were not aware. You get what I'm saying?
Yeah. Oh, yes, yes, yes. Currently, there is no mechanism in place that we have to do some sort of verification on that, no.
The only thing that we can do, the only thing that we can do, since we filed the 9A, is we can check with the county to see when, in fact, that document was received and made part of the public record, which is our responsibility.
Yeah, that's correct. We can do that. When the 9A report is actually posted, it is one of the city's requirements that the selling party must release that, disclose that information.
Sure, I'm very well aware of that.
To them.
But that's beyond our responsibility.
Correct.
Our responsibility is to actually file the 9A.
And that was done, fire department followed this procedure.
I'm sure we assume that the 9As are filed and they follow through and it's part of the public record.
We follow procedure.
I'm sure we don't go back and double check to make sure every single one was recorded properly by the county.
Correct.
I know we don't do that. Yes, Mr. Dine?
I would just recommend, Mr. Chair, that Ms. Gomez provide to the fire department documentation regarding the property transfer, and in that documentation, if it states that the assessment was to be paid by her, that would be the only way to really clarify it. But to have them, the appellate, Ms. Gomez, provide that, they've got to have some documentation for the transaction to the fire department, to the hearing officer. I mean, we don't have the resources to go out and do that investigation. I think it's incumbent upon her to file that document with the fire department and then determines from there. But it's not uncommon to have a sale transfer, as you know from your previous experience in the real estate business, to have certain liabilities because of the price of the property, that some people incur that. So I think that probably expedite the process. Find out what we're going to do with this.
Okay, I figured it out. Thank you, Mr. Zine. Okay, I'll say this in Spanish and English. Señora, señor, lo que ustedes tienen que hacer para ayudar su causa es enseñar los documentos, la preferencia, tomar una copia de los documentos que se llaman Title Policy, póliza de título, cuando ustedes compraron la propiedad. Revisan los documentos que ustedes tienen cuando cerraron el escrow
Sí.
y toma una copia de ese documento y hay que dárselo al departamento. ¿Ustedes saben cómo comunicar al departamento de bomberos?
No, no sabemos.
Okay, okay. What I asked of them is that what they need to do is they need to look through their documents, their escrow documents, and get something called a title policy, get that whole thing, make a photocopy of the entire thing, and then take it over to the fire department so they can show you, okay, what they got when they closed escrow. I asked them if they know how to communicate with the fire department, and they said, no, I don't think so. So how do they communicate that information to the fire department?
Yeah, we'll provide that. We'll make contact with them.
We have the inspector getting his business card?
Yes.
Okay, so you're going to hand them your business card. Este señor le va a dar su tarjeta. Mande la información, llame a él para que puedan entregar esa información a este señor.
Sí,
Okay?
sí. ¿Puedo hablar? Sí, nomás que quería decirle como otros cuando compraron la casa era un foreclosure, la tenía el banco.
Ajá.
Y creo el banco duró mucho tiempo sin limpiar la casa. Está mucho sacate
Sí,
cuando
sí,
nos
sí.
callamos nosotros.
Ajá.
Y ahora yo limpié todo bien, pero
Ajá.
creo duraron como un año que no limpiaron la casa al banco. Y por eso ese cobro estaba
Sí.
llegando.
Mhm.
Sí.
Okay. Basically, what he's explaining, the property was in disarray. The bank owned it for about a year or so. It was a foreclosure, and then they purchased it off the bank. So obviously, there was some mitigation that needed to be done. There's no question about that. Now, the question here is who should have been responsible for the actual $1,826. So, did you hand them your card, sir?
Yes, sir.
Okay. So, ¿ya tienen la información cómo comunicar con la oficina de los bomberos? Okay. Comunica esa información inmediatamente, mañana, el siguiente día, y vamos a tener, vamos a ver esto in 2 weeks? 1 week? Okay. Okay. Is there somebody within the fire department that you, sir, can make sure they can communicate in Spanish in case they don't have an interpreter with them?
Yes, sir.
He's
Okay,
bilingual.
okay. Ellos van a asegurar que hay alguien que puede comunicar en español cuando ustedes están tratando de hablar con ellos.
Okay.
Okay? Okay, so, pero lo tienen que hacer inmediatamente porque para lunes a la semana que entra vamos a ver esto para finalmente, para decidir qué vamos a hacer en este caso. Okay? So we have 1 week till next Monday for them to get you that information. I made it very clear to them that they have to get it to you within 1 week, preferably within the next couple of days, but by next Monday, we're going to finalize this case. Okay? All right. We're going to put this item over, or the item as a whole, for the purposes of Assessor's ID number 5216009036 to be heard next Monday in committee. Okay? Gracias. Thank you.
Thank you.
Is anybody bringing in lunch? Okay. Next, we have Frederick Tylin. Tylin. Frederick T. Lin. Your turn. I do.
Where we go. Yeah, up there.
Go ahead, Mr. Lin.
My name is Frederick T. Lin.
What page are we on?
Oh, we're on
I'm
page
sorry.
page 284.
Page 284. Can you explain to us which parcel number, department?
That's parcel number 54430220006 on page 284.
Thank you so much.
I
Yes,
am
Mr.
the
Lin.
landowner of the APN number 54430220006. It's called North Elysian Heights number 2, tract number 3088. Lot number 73.
Thank you.
Okay, 2 minutes speak is too short for me.
If you
So-
notice, sir, we've allowed people to speak longer so that we can have a full clarity, but all we want to do is make sure that people are mindful of the time, so
Oh.
please proceed.
Okay, if that's the case, I'd like to ask committee members to look at my two-page letters. I can go through one by one. It doesn't matter. The first 2 pages I gave you.
Got it.
Okay, just read through. It's very easy to understand.
Okay?
I'm the landowner of Lot 73 on the map 5443-222 of North Edison Heights number 2, tract number 3088. My lot assessor parcel number is APN number 5443-0222-006. North Edison Heights number 2 is a vacant, undeveloped steep hill area of 76,099 square foot. And my lot occupies less than 1/10 of it. One has to walking about 125 feet westward along Landa Street at the intersection of Bird Street in order to locate my lot. My picture of the lot is on the 3rd page. The unmaintained road is very narrow and will hardly allow a car to pass through. A steep pipe stop gate. A steep pipe stop gate located about 30 feet from the Bird Street entrance prohibits any vehicles to enter Landa Street, making clearing operation and inspection more difficult. There are no houses, and it is very difficult to exactly identify the lot number, location, or APN boundaries unless the city provides some permanent concrete boundaries or stakes that are easily visible. In year 2007, the boundary stakes were more or less recognizable, but in recent years, the boundary stakes are hard to see or not visible at all due to long periods of negligence or their removal during the past brush cleaning operations.
Excuse me, sir, whose stakes are they?
Stake is provided the city or Los Angeles City, probably Los Angeles.
Hold on, sir. Are you aware of what he's talking about stakes? I was not aware that the city of Los Angeles provides staking for private property land.
They do not.
Okay, so sir, you're assuming that the city has staked?
Yeah, in the boundary, there's a stake there already.
Hold on a second.
I don't know who did it, but.
Okay. I'm going to tell you who did not do it.
Okay.
Okay?
So.
The city of Los Angeles, sir, let me speak.
Okay.
You're not doing yourself a favor when you cut off the chairman. Not a good idea.
I'm sorry.
Now, I'm telling you who did not stake the property. The city of Los Angeles is not in the habit of staking private property. Private property is staked by private property owners. Okay? So, I'm not saying that there are not stakes there. All I'm saying is, if stakes are put on private property boundaries, and those stakes deteriorate, unless the adjacent property is the city of Los Angeles, and for some reason they're doing some kind of work on that property, they're not going to go out and stake a private property line, okay? So therefore, when you mention that those stakes used to be visible, and they're no longer visible, do not assume that the city of Los Angeles is going to go make them visible again.
Okay.
Continue.
That is my mistake if it's not correctly mentioned. But apparently there were stakes, I found out, okay? That's the truth. I don't know who did it, but there were stakes. Probably fire department did it for the inspection purpose.
I believe that there are stakes out there. I just wanted to make sure you understood who did
Okay,
not.
I understand. Okay, I don't accuse city for that.
Okay.
Okay. On June 1st, 2009, the Los Angeles Fire Department, abbreviated LAFD, sent me a notice to clean the brush off the land with the deadline of June 16, 2009. On June 13, 2009, 3 days ahead of deadline, I had the brush cleaned by a third party. 3 months later, on September 24, 2009, I received a second notice to clean the brush off the land. That is 3 months later. This second notice was clearly a mistake on the LAFD's part, as I had evidence of the cleaning being met by the deadline. On September 25th, 2009, 1 day after I received the second notice, I mailed the LAFD my protest, the cleaning operation receipt, and on-site photos of the cleaning land. The LAFD must have either identified the wrong property, since it is hard to distinguish the boundaries of the lot, or they checked the land well after their own proposed deadline. The LAFD, however, never sent me a reply letter or email until January 25th, 2010, this year, when I received an invoice BC 100170002 for $1,312. I cannot understand why it took them 4 months to send me a reply via mail, email, or phone call. I should not have to pay this fee due to their laziness or negligence. On November 13, 2009, the Los Angeles Lot Cleaning Division, abbreviated LCD, of the Department of Public Works, gave me a notice order that APN lot 5543-022005 has to be cleaned. After receiving my complaint about misidentification of my lot APN against my neighbors, the LACD wrote a letter
One second, Mr. Lin. You may have stumbled on the golden nugget of your entire argument here. Let me ask the department a question. Mr. Lin has just claimed, he has just stated that LALCD wrote a letter of apology on November 17, 2009, stating that they identified the wrong property. Do you understand? Do you know what he's referring to?
I'm not sure, but this is referring to lot cleaning that normally comes out and does many of the properties that are in the zone also. There are certain amounts that they do, and it appears as though they sent him a notice saying that they cleared the wrong property, right?
They sent him a notice saying that they cleared the wrong property.
That's what I understand, yes. That's what his statement was.
What does that mean? What does that mean with reference to the person who's being told we cleared the wrong property?
I'm not sure of what their correspondence was referring to, but the fire department uses parcel maps that are written and provided by the county assessor's office with dimensions and diagrams of where those property lines should be. The fire inspector is trained on calculations on how to determine where those property lines should be.
Got it.
Those property lines were determined to be Mr. Lin's property. It remained in noncompliance, although the department record does reflect that some work was done, but it was still in noncompliance. And that's why he got a second notice of noncompliance. When we got no action on that, we went forward with abating the hazard ourselves.
Now, but what Mr. Lin is pointing out to us is that apparently it's not that easy to know where the true property lines are. And therefore, how do we as a department know that we're making the proper clearance activity and notices and requirements on the proper property?
Yeah, well, like I just mentioned before, we utilize those maps that are provided by the assessor's office. The inspector is trained to be able to calculate where exactly the estimated dimensions of where those properties are. and he utilizes those calculations, determines who is the proper owner, and that owner is notified. If a property owner disputes where those property lines are, they are to provide proof of that. And many property owners do that. They will go forward and hire a private property surveyor who will come out and survey the property. Those documents are submitted to us. We review them. We compare them to what our calculations were, and we'll go forward with a decision.
Okay. All right, did you hear that, Mr. Lin?
Yeah.
The actual boundaries of the property that you're talking about right now, at the end of the day, if you protest to the department that perhaps they got the line wrong, or they're looking at the wrong piece of property and they should be looking over here instead of over there, and telling you that you need to clear this, and you say, no, that's not mine, this is mine, and I cleared it already, that when you get into a dispute with the department like that, clarifying those property lines is your responsibility. Okay? Did you hear what he just said?
Yes.
Okay, go ahead.
Okay. Where is that? So, LACD wrote a letter of apology on November 17, 2009, stating that they identified the wrong property, proving that my lot had nothing to do with violation. The LAFCD claims that they also took pictures of lots on their inspection dates, May 22nd, 2009, first inspection, September 17th, 2009, second inspection, and October 15th, 2009, third inspection. These pictures, however, cannot prove that the lots that were not cleaned, including my lot, since there are no boundaries or identification landmarks on these photos. The LAFD's evidence was not presented to us for our verification during the assessment hearing on July 14, 2010, nor do they have the city contractor's name, address, date of work, payment receipts. Furthermore, it doesn't make sense for the LAFD to inspect the lot 3 months after their proposed deadline. Vegetation can be grown during this time. The LAFD claims that their reason for the non-compliance penalty charges is based on their demand that further cleanup is required due to regrowth after the rainy season and a 6 months elapse subsequent to my initial cleanup on June 13th, 2009. This is an unreasonable demand considering they did not make me aware of the requirements until July 15th, 2010, 1 year after I had cleaned the property.
Okay, Mr. Lin, in the interest of time, I'm going to give you an opportunity to make your last statement, and then I'm going to ask some questions of the department. I'm not going to let you finish reading it. You've submitted it for the record.
Okay.
I've already read it. So what's your last point?
My last point is, please, on this appeal, please carefully read on my letter of appeal, and I appreciate your consideration to reject the recommendation reported by the Board of Fire Commissioners. Please revoke all charges and invoices demanded by the Los Angeles Fire Department.
Thank you, sir. Now, when it comes to these hearings, if the department states in any way that they have photos of evidence of the subject property or what have you, are they brought to these hearings?
Absolutely.
They are?
Yeah.
Mr. Lin has just stated that the department did say that they have photos of the subject property, but Mr. Lin is saying that on a hearing on July 14th, that although it was stated, the photos were not shown or presented during that hearing.
Yeah, I wasn't at the hearing, but according to the report, he says that he did view the post, bid, and final stages, which were photographs, and a copy of the Zemas map. So he reviewed the entire file. What I did hear Mr. Lin mention is that he did not see who the contractor was who actually...
That was the second thing that he said did not take place.
Yeah, that's
now,
correct.
when it comes to who does the contracting work,
yes,
do we provide that to the property owner?
No. That's normally not provided at the hearing, but if it's requested, you can see who, we normally don't provide the name of the contractor. We'll provide what the cost was, what they charged the city.
And the date that they cleaned it up.
And the date it was cleaned, and that contractor has to submit photos what the property looked like the day they stepped on it, while they were doing the work, and what it looked like when they finished.
Okay. And those photos that you just mentioned are part of the record?
That's correct.
Okay. And those photos, you're saying if Mr. Lin wants to see those photos, he can see them?
Absolutely.
Okay. But they're not necessarily shown at the hearing?
He's claiming that they weren't shown at the hearing, yes.
I didn't ask that. I said, are they shown at the hearing?
Yes.
They are shown at the
They
hearing.
are shown at the hearing.
So they should have been there, ready to be seen or shown?
Yes.
At the July 14th meeting?
Yes, yes.
And Mr. Lin is saying that the photos from are you saying that the photos from the contractor's work were not there to be seen at the July 14th?
I saw some of them, but I cannot recognize which is contractor, which is Department of Fire inspectors. And those photos are almost non-identifiable because it's just a photos. There's no boundaries, stake or anything. And how could I identify this is my plot?
Mr. Lin, on the lot line issue, you're losing that argument. It is the responsibility of the property.
Yeah, but the photo cannot find out. I cannot say, if I say the look at photo, I say this is not exactly the...
I'm going to give you some advice, sir. For future purposes, if I were you, especially this seems to be an irregularly sized lot, for future purposes, I would recommend that you go ahead and have it clearly staked so that other people don't make mistakes about your property and your responsibility in the future. That's just some advice I'd like to give you. You can do with it what you wish. I am not the authority on that. I'm just trying to be helpful, okay? Now, department, when it comes to this particular case, is there anything in the file that you're aware of that causes you to believe that the property that was inspected, the property that was cleaned, is not part of the property that Mr. Lin is talking about?
I'm sorry, one more time.
Mr. Lin is talking about his particular property. Part of his contention is that some of the activity and the notice perhaps was not due to his property, but due to adjacent properties. Is there anything in the file that leads the department to believe that perhaps there's some credence to that?
No.
Any questions? No. Another thing as well, Mr. Lin, it was mentioned in one of the previous presenters, owners of the property, who's here to protest these fees on their property, and we stated once again that the clearance of the property is not only required when the city fire department notifies an owner. Keeping the property cleared for fire purposes is the responsibility of the owner 365 days out of the year. You stated earlier, and it is also documented in what you submitted in writing, is that some growth may have occurred since you cleared it, and then they did a reinspection, and perhaps they're looking at later growth. But the bottom line is, whether it's old growth, new growth, the bottom line is, it is the responsibility of the owner to make sure that it's not a fire hazard 365 days out of the year.
I understand that.
So when the department goes out there and there's a fire hazard, and in their professional opinion, they believe that it is currently a fire hazard today, if they went out there today, then that property is in violation today. Okay?
My argument is that third inspection is somewhere around this year, and it's already, grass is already green because of the rain. And when you compare with the brush, of the brown brush, that is most fire hazard. So I understand the city is giving us a notice once a year to clean before the grass become, fire hazard. So I wasn't aware that you have to clean twice a year or 3 times a year. Although I understand, the fire hazard should be eliminated. The best thing I recommend is, this kind of a problem is never end. So I suggest city how to develop the area with councilors or city planners.
Got it, okay. But
That
we're-
is the best way to solve the problem.
I appreciate you trying to think, how can we make it a better process, but we're here to talk about what occurred in 2009. Okay, any questions, members? Any questions? Okay, do we have a motion to either concur with the department or modify the department's recommendation?
I'll make a motion to concur with the department for the fine of $1,312.
The total assessment of $1,312, correct?
Correct.
Okay. Ms. Perry?
Fine.
Okay, seconded by Ms. Perry. Okay, it's unanimous. This committee concurs with the department of the total assessment of $1,312. Thank you. We concurred with the department, sir. Next, we have Farhan Levias, Edna Thompson.
I got him here. Page 376.
Page 376, and the property owner is Edna Thompson, correct?
That's my mom.
But is that the property owner?
Yeah, me and my mother.
Okay.
$376?
376, yeah. Percy R. and Edna Thompson are the owners of record.
Right,
Okay.
right.
Go ahead, your name again for the record, sir?
I'm the son of Percy Thompson and Edna Thompson, Carlton Levias.
Okay, go ahead.
Okay. First of all, good morning. I think this one is pretty black and white. For the last 6-7 years, I've had this property. It's been a bedrock like Fred Flintstone. It's been nothing but rocks and dirt there for 7-8 years. And Inspector Gabby was the inspector that has, for many years, inspected this property. In 2008, he cleared it. And we had a discussion that it was rock. I told him that we have never had to clear out anything on that property because it's been rock and dirt most of the time. 2009, I get some letters about brush clearance, and I called Gabby on the phone, and I tell him, I said, Gabby, I'm getting some brush clearance letters. He said, it's got to be a mistake. He said, let me go out there, take some pictures, and see what's going on. So by the time he gets back with me, I get the second notice. And he says, yeah, he said, there's some trees and some stuff out there. I said, that's impossible. So I go out to the property, and we go out there, and I have 13 trees on this land that was dirt and rock for 8 years. And soon as we come around, because this is like a bedrock, it doesn't look like it actually belongs to anybody. It actually looks like it belongs to the county of Los Angeles. And I've been told that I'm supposed to clear within, is it 5 or 10 feet of the roadway? Ironically, these are where the trees are, about 10 feet from the roadway. Coming around that corner, I noticed that there was a sign that said, a project by the State of California Environmental Services, Beautify the Canyon, Adopt a Canyon program by Paul and Ezra. And
Keep going.
I did some homework about the Adopt a Canyon program, and I found out that they have a program set up from the State of California, and people can donate their time. They have donations for these programs, and they pick certain areas of Los Angeles, and they take it upon themselves to beautify that particular area. Well, when I brought that information back to Inspector Gabby, he knew nothing of the program. I talked to several other inspectors who knew nothing of the program. I knew nothing of the program. And
Okay, you're going to have to get to your point on what's the relevancy of that program and this particular responsibility of this private.
Because the responsibility of it is that I had no knowledge of that, no knowledge of those trees, had no knowledge that they put those trees on our lot, and for the last 4 or 5 years, we had dirt and rock. And so when I went by there for the first time, and saw that, I submitted some of those pictures, but nobody knew who Adopt a Canyon was.
Okay, hold on a second. In the pictures, there's a handful of pictures you provided them.
Yeah, if you notice on the picture, yeah, I'm sorry.
Hold on. Now, I see in the pictures there are some trees. The trees seem to be green.
Absolutely.
But there's some brush on the ground, some grass, maybe a foot to 2 feet long in general. Dry brush. Are you contending that dry brush was not there?
You know what, sir? That's not
until the trees got there.
No, that's not even dry brush. What they did was there was some foundation there's some vegetation that they put there when they plant the trees.
Okay.
And so that's part of what you're seeing. So that wasn't even there. In 2000,
what I'm calling dry brush, are you saying that's the vegetation?
Are you talking about on the ground where the trees are?
I'm talking about here, sir. I'm going to show you a picture of a tree with a staked tree. And then around that tree, within 5, 10, 15, 20 feet or so, in this picture is dry brush.
Exactly. Now, what my instructions were for the last 7 or 8 years were 10 feet from the roadway. 10 feet from the roadway. And that was it. And
okay.
And so that's what has always been done. That's what was done in 2008 when me and Gabby went by there. That what was done. But there's been an incredible amount of growth as a result of the things that the Adopt a Canyon program planted there on my property.
Okay, now hold on a second. Do you understand that your appeal to this committee and the Adopt a Canyon program are two different things? If you have contention with the Adopt a Canyon program and they touched your property, altered your property, did something to your property, and as a result of that, caused you to have some kind of responsibility to the city of Los Angeles based on the fire inspector going out there, that's a totally different story. Now, if you end up being assessed this $1,276, you might be able to go up to them and take them to small claims court or something like that and say, I wouldn't have had to pay $1,276 had you guys not messed with my property, because before you started messing with my property, we never had a problem with the city of Los Angeles. You get what I'm saying? So those are two different things. What caused this to happen, although I could feel for you that somebody touched your property and altered it in a way that caused you some kind of other responsibility, I can feel for you, but I can't translate that into saying, well, Adopt a Canyon messed with these people's property, and as a result, they ended up with brush that they never used to have, and now they got into this situation with the fire department of the city of Los Angeles, and now we're sitting here trying to figure out if we should assess them or not.
Let me say this. That wasn't done by a person that did some landscaping in the area. It wasn't done by anybody that bought some real estate that just wanted to beautify the area. This was a California program that we knew nothing about. Okay. If I had known about that program, if the inspector, Gabby, who assessed my program, if he had known about it, we would have taken care of it way before that date, way before the time. I haven't had to look at that property for about 4 or 5 years at a time. We're not even in the country that often, and it's a bedrock, sir. It's never been any growth up until last year. And so what I'm saying
with all due respect, we're not talking about 2004, 5, 6, 7, and 8. We're talking about 2009. So hold on a second. Is there any light you'd like to shed on this particular case?
Yeah, apparently this is exactly what happened. In fact, the hearing officer heard his testimony at the hearing of May 14, 2010, and the hearing officer actually did reduce his assessment down to $976. So he did reduce it $300 based upon testimony that it would be a hardship, and based on the information that he submitted, they reduced it $300. But it's still the property owner's responsibility, regardless of who encroaches on their property. We're unaware of those. It could be a private owner, it could be any entity that could have encroached upon the property. It's the property owner's responsibility to secure his property, maintain it, make sure it's well maintained, especially in the high fire severity zone.
You know, may I say something?
You're welcome to say something. Make it brief.
Yeah, I've been maintaining the property for 8 years. The only argument that I have is that I have the county of Los Angeles charging me for something that the state of California did to my property.
We're the city of Los Angeles.
The city of Los Angeles. And I totally understand that I'm responsible for it. But I want us to take a moment and just look at the entities that's involved here. I'm not talking about some independent landscaper that did it. I'm talking about proven documents that the California did it, a program that they were funded and they lost funding to do it. I'm saying, and this is what I propose to you guys. I would be willing from this point, because we had no knowledge of it, to totally take care of some things that they did that they lost funding for. From this point on, I'd be totally willing to take, because I've been brought, this information has been brought to me now. But even up to date with Inspector Gabby, even he said it has to be the wrong parcel number, because he'd been out there year after year. And so when he went out there and he took some pictures, he said, yeah, it is the right parcel number. And so I brought him that information. I brought it kind of late because I didn't know. But in light of the entities, and I know what you're saying, that I need to go get with the Project California that doesn't even have any money anymore, and try to sue them for $1,400 because they're coming in like everyone wants. They want to see Mulholland beautiful. And if you had an opportunity to go by there yourself, you'd find that particular parcel of dirt land is and where they planted the trees and where it is, it could possibly look like it's not owned by him.
Okay. Ms. Perry?
I have a question for the department. I saw the pictures of the trees, and the planting of the trees, is that what triggered the brush clearance, or is it the vegetation that occurs there between the rocks?
It's a possibility of both. And what happens is that even though there are trees still need to be maintained as well. And I understand what the gentleman is mentioning, that for years he never had this problem, and all of a sudden it's out of the blue it happened, because even the inspector was caught off guard by it. But based upon the members, the gentleman's good faith and him attempting to try to comply, I think that's why the hearing officer tried to weigh in favor of reducing the amount of cost there. But the trees are also an issue also that we look at. Any vegetation, I don't care if it's green, brown, yellow, if it's there and it's not maintained in a wind-driven fire situation, it can contribute to the spread of fire.
But when it comes to these particular trees in the picture, these are maintained trees, right? It looks like
They're trimmed up, yes.
The branches are high enough off the ground, they're still green, they're not dead trees, right?
That's fine.
So the bottom line is the vegetation is really the issue here.
They planted a lot of vegetation too, because I had dirt. And let me say this.
Hold on one second. I need to clarify something. Department, what we're looking at right now, cost of clearance $250, administrative fee $1,026. The total assessment that we're considering is $1,276. Is that the reduced amount already that the hearing officer talked about?
On page 377, the bottom page, the total assessment due is now $976. So he or she, the hearing officer, reduced it by $300. So he's looking at an assessment right now of $976.
$976, not $1,276.
Correct.
Okay.
May I say something, and I'll be finished?
Got to make it brief.
I'll make it real brief. You guys, for the rest of my life, as long as I own that property, for what California did, I got to maintain it now. And I would be willing to accept that responsibility. But in light of the fact that neither I or the inspectors had that knowledge about what happened to that property, what California did, I'm willing to fix it from this point on.
Okay. Look, I keep telling you, what California did, as much as I'd like to take responsibility for everything California does, I tried that once, it didn't work very well for me.
I'm a private independent property owner,
Look,
and I'm looking at
understand.
everybody in the same family.
Look, I
California and
understand.
LA is the same to me.
I understand. Look, the department already reduced it by $300. like I said, I feel for you. I feel for the fact that somebody tried to do something nice, and as a result of that, it caused burdens on you. And when I'm talking about you, I'm talking about your parents, because apparently it's Percy and Edna who own the property, and you're a good son. You're helping them out. That's wonderful. But the only thing I can recommend to this committee is that we just concur with the department and be glad that they reduced it by $300. And if you really have a beef with the state of California, you probably can sue them, because they went on a private property and they took action on a private property, which, even though they're trying to be nice, it's kind of awkward for them to do that without noticing the property owner. We have strong property rights in this country, and for somebody to do that, it's kind of weird.
It wouldn't be fair for the sake of what we all actually see here to modify it down to just the cost of what it costs to clean that property up for that year, because I got to maintain this from now on. If it was up to me, I wouldn't have never did it. But it's going to cost me from now on to cut down those 13 trees that they planted there and all the vegetation that they did there. It's going to cost me from now on, sir.
I understand. Okay. Is there any motion from the committee other than concurring with the department?
Yeah, I guess, no, I can't think of what else to do. They've written down the fees once. And I would suggest that he get in touch with the state of California on their Adopt a Canyon program and see what he can do to see if he can get some mitigation from them.
Anything else? I concur. Okay. All right, the motion before us is to concur with the department. With that, the vote on that is 3-0. Okay. Not seeing otherwise. Sir, it's 976. Okay. Would you like your photos back? Yeah. Here you go. Okay. Anita Akalagapar, I do apologize if I said that wrong, but you're going to have an opportunity to clarify how to say your name for the record. Okay. Hold on 1 second before you get started. Page number on this?
You're searching right now. Your 18.
Assessor's ID.
Show it to them so they can announce us what page we're going to be looking at. Thank you, ma'am. You can sit down, Anita.
2181.
Page.
No, this is the APN. It's 2181. I'll get the page number for you here.
18.
Aklafar? Yep. Hesperia Avenue? Yep. Page 39.
Page 39?
39.
Okay, Anita, you can start.
I like you are honest. This property, we have 22 years and 15 years. I have a one gardener, Marius, every Wednesday afternoon coming to clean the house. I didn't get any notice, and after they sent me notice, I must pay $2,226, and I call and ask what is that I must pay, and they said they sent the notice for the clean, but they return to us. And we went to the one public hearing in Van Nuys Court, and with my husband, and we talking. We never get any notice to clean because every week my gardener coming to clean up. If I get the notice, I must clean more than this. I go clean. I have just one green tree over there. I don't have anything. A small house.
Okay. Now, you're saying that you didn't get any notices in the mail?
Nothing.
In the mail?
No.
Okay.
Nothing.
But according to the documentation and the report from the department, that the fire inspector's photographs clearly show the property red notice, at least the red piece of paper at the problem site that's posted at the site. But
I don't live that property, and they knows I don't live, and they have my address, actual address, and
so are you saying that the gardener goes to your house where you live?
Yes, I
And then
give
if
the key.
you would have received notice, you would have sent the gardener over to this property?
no.
The gardener goes to this property every week?
Yeah, every Wednesday afternoon, I have a gardener 15 years.
Okay.
That street, that gardener go in every Wednesday and clean the house. And I didn't get any notice. Suddenly, I get the notice I must pay $2,226. And when I called to that number, they write, and they said, yes, you didn't get the notice because the notice coming back to us.
Okay, thank
They had
you.
in the file there.
Okay, hold on. Department, did the notices come back to the department undelivered?
According to the record here, it shows that the mail was delivered and should have been received. I don't show any record of the mail being returned. However, we can...
Does the department record when letters are returned? Do they record it for the file? That on this particular file, this particular notice was at least mailed and it was not delivered because it came back to the department?
That's what she's saying, but I don't show that.
No, I'm asking you process first. I'm
Yes.
going to get to the, okay.
Yes.
So therefore,
Yes.
had you received those notices back to you, the department,
Yes.
you would have recorded that on the document.
Correct.
And you're saying that this particular file does not show, as far as the department's concerned, that the department received those letters back.
Yes.
Who told you,
have it?
hold on one second, who told you, Anita, who told you that the department got the letters back?
Yes, I have the record. I would like to appeal the decision, and for that, I have the name. Mr. Dean, D-E-A-N. He told, the notice is coming back to us. You know the Mr. Dean, D-E-A-N?
So according to...
Can you call them as?
According to your records, Anita, Mr. Dean, the inspector,
Yes.
did confirm with you. Was it your husband, your sister, or was it you? Okay, you. Mr. Dean confirmed to you that the notice had been sent, the notices had been sent back.
Yes.
Returned to sender, basically.
Yes.
Okay. Is Mr. Dean still working for the department?
Yes, Inspector Dean is still working. We can clarify that.
Okay. All right.
Mr. Cardenas,
Yes.
may I clarify something?
Sure.
This issue of mailing versus posting has come up in the past, and City Attorney Janet Jackson has inferred to us that either posting or mailing, they both hold the same weight. Posting the property is legal notification as much as mailing it through the mail.
Sure. I have the right to yell at my kids. I can't hit them. That would be illegal. But yelling at my kids doesn't make it right.
Yes.
Okay. And especially when an attorney infers, that's not exactly case law. Okay? So, we're trying to figure out, the reason why I'm asking tertiary questions to people who come and want to appeal is because I want to figure out what is the right thing to do here. Not necessarily what is just black and white and legal. Sometimes it comes down to black and white and legal. Okay? So, the bottom line is we have somebody saying that there is a Mr. Dean from the department who has been confirmed that he's one of the inspectors?
Yes.
Okay. That Mr. Dean had said that the letters had come back, returned to sender, and so let's give this case until next week for the department to clarify with Mr. Dean as to whether or not on this particular case that the letters were sent back to the department. And you got a bigger problem. If he does say, yeah, they were, why isn't it in the file so that you know that? Because you just told me process for the department is, if the letters are returned to sender, it is noted on the file, correct?
That's correct, yes.
Yes, Mr. Zahn.
A couple questions. It states that the appellant did not receive the first notice of compliance. We need to determine if there were subsequent notices that were received.
Yeah, that's another question that I have for the appellant. She received the bill and went to the same address. That's how she knew she had the appellant. That's how she knew.
Coming, but the notice not coming.
How long have you lived on Wilshire Boulevard?
13 years.
13 years?
Same
How long have you,
How long that I have the,
how long have you owned the property?
22 years.
Have you received notice in the past about clearance of the property?
Not.
You've never received notice?
Not,
Like it was the first time it was out of compliance.
This was the first time?
the first time. And I have one green tree. If they want it, I cut it. Let me know I cut now. I don't like they send me the bill, and after that it's coming another $300 bill.
And for
One
the
is
fire-
2,206.
And for the fire department, if there's been notices served in the past on this particular property to this particular appellant, for the record, if you could find that out.
I can't.
She said she's never been noticed before. I want to find out if there has been
So in
notice.
other words, it appears that this property was in compliance, perhaps,
in the past.
and this is the first time that this process was incurred with this particular property owner.
Just want to confirm and verify all that information.
Yes.
Thank you.
Okay.
Thank you, you're honest. Whatever you wanted, tell me now. I do it.
The department will communicate with you when it comes to the physical nature of the property, okay? Okay. So, this item will be put over till next Monday so that we can get clarity on some of these facts, okay? Thank you.
I must say something, I must do something, what I must do.
Okay, you'll know more in the future what to do, okay? Thank you. Yes. For those of you who are putting this item over till next Monday, this committee appears to be, will be noticed for next Monday at 9:30, the commencement of this hearing of the Public Safety Committee next Monday at 9:30. You should be here if you want to hear the outcome of your particular case. Thank you. Leslie Kinnikin. You want to give us the parcel number so we can get going, sir?
Thank you, sir. What's the parcel number? Okay, I'll give it to you.
Yeah, with a K. K-I-N-I-K-I-N. I'm assuming that's the property owner of record. Okay.
They're still waiting for parcel.
Parcel number... Shoot. Can't tell which it is.
Should be at the top there.
AP, would that be APN number?
Yes, that's
Okay, 2544012007.
Here it is. Do you have the page number?
2544001207.
Yep.
Page 127.
Page 127. Please commence, sir.
Well, we have somebody cleaning up at least twice a week, not twice a month or twice a year.
Okay.
We clean up all the time. We had the same thing happen in 210, as you can see. They say vacant land. It's not vacant. You can see that it's clean and clear. And they came, and only Victor can tell you, I travel a lot. I have a business. We keep the place clean. There was never a problem. It happened, the same thing this year. They said we had to clear. I went to the fire department, which is right in front of the house, and they sent the fellow back and he apologized. He said everything was fine, so we were cleared. It's the same thing in 209. That area they said is vacant, is clean. Now, they sent the team over to clean up And Vic can tell you, I wasn't there. They sent a team over from somewhere, I don't know. They asked to use the back to clean up the neighbor's property, which you can see there with the truck parked there. We helped her for 2 years. When we clean our place, we clean hers, because her husband passed away. She has a big piece of property. We've never had trouble before. In 2009, I just wasn't around enough, but Victor is there every day watching my house.
Victor, did you want to add anything?
Tell him about the cleanup.
Go ahead. Si quiere hablar en español or in English or whatever language you prefer to speak in.
Sería mejor en español.
Está bien.
Le traían una carta pidiéndole permiso para entrar a limpiar para arriba, hacia arriba del cerro, pero era la otra propiedad que seguiría, no es la de él.
Okay, according to Victor, apparently that one of the notices seems to have been in reference to the property above them, not necessarily their property. ¿Sigue?
It's, part of it's mine, but part of it's the neighbors as well.
Okay.
And when the cleanup team came, they went after one tree that was, I thought was fine up there. It's been there for 30 years.
Mhm.
They worked the whole day on Grace's property, my next-door neighbor.
Mhm.
They cut all her trees and did all that work. I wasn't there. Victor is the one. That's
Now, hold on. Do you know if your neighbor got a bill?
I don't know. She would have.
You don't know if she did or did not?
No, I don't know that.
You don't know that? Well, if
All
you're
I
going to
know is-
refer to the work that was done on your neighbor's property, I think you might be inferring that maybe you're being charged for some of the work they did on your neighbor's
No,
property.
I'm not saying that.
No, you're
I'm
not?
just saying
Then
that
why did you tell me that they
come
spent
up
so
on
much?
my
Hold on,
property.
sir, do not cut off the chairman. Why did you, I just want to understand why you shared with us the fact that they spent so much time on your neighbor's property. Now, if they spent time on your neighbor's property and you think that they may be charging you for other work, then let us know. But if they spent time on your neighbor's property, I'm just trying to understand what the relevancy is to the case that's before us, which is the cost of clearance, as far as I see, is $400 and the administrative fee is $1,026. So is there any relevancy as to why you're sharing with us how much time they spent on your neighbor's property?
Well, they didn't say they were actually coming on my property. They asked for permission to use the back to work on the property up above, is what they...
Okay.
And well, I'm trying to tell you, Victor's the one that talked to them. And they wound up spending the whole time over at Grace's property, cleaning her trees. And you can see in the picture, the property that they're talking about, it says it's nobody, it's empty property. It's not. Look at the pictures. There's no problem up there. Now, this year, the same thing happened early, and he came back and apologized. And he passed everything fine. It
You
just
better keep
makes-
checking your mail to make sure that it follows through that way, that everything's fine.
Yeah, look at the picture.
I looked at the pictures.
Okay, look at the picture, and look at the date on the top, and look at the date on the bottom, please. On the picture they took from the air. That's what's causing all the trouble. No, not that one.
Not these?
The one that you sent, they sent me.
I don't have that.
Sure you
I'm
do.
sorry, this one, you're talking about the aerial.
Yes, look at that property and look at it now from the pictures. It doesn't exist anymore like that. And look at the bottom, it says 2006, and then I go on from 2007,
Okay.
and on the top it says 210. That gives off the wrong impression.
Mhm. Okay. Señor, ¿usted estaba allí cuando llegaron para limpiar las propiedades?
Sí.
Okay. I asked him if he was there when they came to clean the properties. ¿Y qué ocurrió cuando llegaron ellos? ¿Trabajaron en la propiedad de este señor o trabajaron en la propiedad de la vecina? ¿O qué trabajo hicieron? What work did they do? Did you notice them working on the neighbor's property or this man's property?
El neighbor,
¿Mande?
del vecino.
Del vecino. Cuando llegaron, ¿no viste que hicieron trabajo en la propiedad de este señor? Cuando usted estaba allí.
No,
¿No hicieron trabajo en vista de usted cuando... Okay. What he's clarifying for us is that when he happened to be there when they came to do clearances, and that they spent their time working on the neighbor's property, and he did not witness them while they were there working on this man's property. Okay?
Okay.
Now,
One more thing, Victor, tell them they brought the truck into the neighbor's property too, van.
Sí.
He told me that.
Usaron su propiedad, pero para ir a limpiar al lado de los neighbors.
usaron acceso de este señor, la propiedad de este señor, para llegar a la otra propiedad. So basically what he said is that they used this man's property for access purposes, to take the truck through there, they gave him permission to work, and then they ended up ultimately working on the neighbor's property, not on his property.
Okay.
Okay, go ahead.
Based on the department information, the notices of noncompliance went out to the address on record. In the file, there are photographs that are showing the condition before, during, and after the clearance. And when we send the second notice of noncompliance out, we send out a map, which is what that aerial map is. That is just a GPS map of that current year that it was actually done. It's on
Yeah,
record.
this
And it
picture
just
was
helped
not,
them.
excuse me, sir, but this picture was not taken by the fire department.
Right.
This is a picture that's pulled down off of the computer based on a database of pictures that were taken on properties whenever, okay?
But read the
just-
report. It says it's vacant land. It's not. It's been cleared.
Okay, so what Mr. Kinnikin is trying to tell us, aside from this photo, it appears that the department is referring to the property as vacant land. And what he's saying is, it is in no way vacant land. So, does the department refer to properties that have structures on them as vacant land? Are you claiming that there are structures on the property? Okay,
You can see it in the picture.
it's okay. Yeah, go ahead.
The information that you see there with situs address, we don't alter that at all. That comes directly from the county assessors. That's how they have it recorded in their information.
Yeah.
So that's why it says vacant land. We don't alter that at all. It comes directly from the county
Okay.
assessor's office. So that's.
But an
that's-
inspector goes out there and sees it, and if there's structures on it, you continue to call it vacant land based on what the aerial that you get from the county, or based on what the inspector describes?
We base it on what the area, what the county assessors has. When the notice is issued out, the notice will reflect a structure and where to clear for that structure.
Okay.
So
And that took place here?
that took place here.
Regardless of whether they referred it as vacant land or not, the bottom line is they notify the owner what portion of his or her property needs to be cleared.
Correct.
Okay. Are you contending that you did not understand what portion of the property, structures or not, needed to be cleared?
But we've been passed every time, and nothing was changed. I can't imagine what the...
So what you're telling this committee is that in 2009, when you went through this process of being noticed and you're confused as to why they're bugging you, what you're saying is there was no brush to be cleared on your property that you could tell. Is that what you're saying?
Right. If there was anything, they could have told, my buddies are working on it all the time.
Okay, but at the same time, what you're saying is, as far as you can tell, when they're noticing you that your property needed some clearance to happen, that you're sitting there confused saying, I don't know what they're talking about.
Well, nobody
I don't see
showed us.
anything. Huh?
Nobody showed us what we should clean. I mean, everything was okayed. The first time they came up, we cleaned everything and we did everything right. Nothing has changed. You can look at the property. I mean, it's clean. You know, as much as it can be legally.
Okay,
Just, we haven't really done anything wrong that I know of. They're only talking about that one piece up there. Look at the size of the property. I mean, we keep it all clean.
no, I looked at the pictures. You took pictures when it's all green. I hope it's like that year-round.
It is. Like I say, they work at least 2 days a week, sometimes 3, right, Victor?
All right. Department?
These photos that we had on file at our office were available for Mr. Kinnikin to view. He did not appear to the brush clearance hearing.
What date was that hearing?
It was scheduled for May 11th, 2010, and he was not present, did not appear, didn't present any evidence.
Mr.
I didn't
Kinnikin?
even know it existed. I travel all the time.
Okay.
I have a business, I have an aircraft company.
Okay.
I'm not there. Victor is around there to take care of the house most of the time.
All right.
But, we did go to Van Nuys. We went to the brush control, and they showed us that same picture, and we tried to talk to them, and we had pictures and everything. They didn't give us a chance to do it. I had Victor and his helper and myself. We went there, and they didn't want to listen to us. They didn't want to talk to us. I'm
Okay.
not making that up.
So what happens when somebody goes to look at photos? The department zips their mouth and lets them just look at the photos, and the person says, this is not my property, this is photos from the neighbor's house, or what have you. The person just sits there and says, take it up with the judge. What happens when people are shown the photos, when they actually see them? Like you just mentioned, they're available for people to be seen.
Yeah, when anyone that wants to come in and view photos of any work that the city fire department has done to abate a hazard, they are available for them to view at any time they want to call in, schedule an appointment. Everything is reviewed with them and explained with them. If they dispute, this is not my property, this is not my property line, my property doesn't go back this far, then that is where we have to say, again, you must provide proof, because based upon our calculations and estimations that we've received, these are the dimensions of your lot. It extends this far or
But
this
not
wide.
standing there, for example, in Van Nuys looking at the photos. That needs to be done at a hearing?
That can be done even standing there also. That is
Really?
Yes. If they have
So,
questions, they
okay,
can be
Mr. Kinnikin, you just described something that's very different than it's supposed to happen. The department is saying that when you were looking at those photos, somebody should have been receptive and been willing to dialogue with you about your contentions. And you're telling us that when you said, first of all, tell us what you told them when you saw the photos, and then tell us what they told you.
This was in 209. And
Okay, fine.
we went over there, and we were trying to show them this is wrong due to that picture from the air. That was the beginning of that, because that's what they showed us, okay? And we tried to explain to them that's all been cleaned. It's been cleaned since 208. And they didn't respond. There were three of us there, and it was lunchtime or something. They didn't want to talk.
Okay, when you say
I'm not-
they, you were
They weren't
talking,
being mean or anything. They just said that...
you were talking to one person, two people, did they have a badge on? Were they tall,
Two with
skinny,
that-
short,
One
what?
was a lady, yeah.
Okay. And they just stood there and nodded their head, and then
Said,
you left?
This is not the time or the place.
They said this is not the time or the place. That's not
Victor
what you
was
just
with
told
me.
us?
Victor was with me. They didn't have time or something. I don't know.
Okay, Victor, ¿qué ocurrió cuando fueron a Van Nuys? Este señor está diciendo que él quería explicar que no hay problema, por qué le están mandando este bill, etcétera. I'm explaining to Victor that apparently you were contending, Mr. Kinnikin, to the person standing in front of you, or persons, that, hey, wait a minute, there's something wrong here, I don't see what the problem is, etcétera. ¿Qué ocurrió?
Se fueron a la computadora, le dieron la foto esa grande que está por ahí.
Okay.
Eso fue lo que le dieron.
Okay, Victor's saying that their only response was to go to the computer, print this out, and hand it over.
But they didn't give it to us.
Yeah, they give it to you.
They wouldn't give it to us. I asked for it.
Okay, your witness, Victor, is just telling me in English, even though he prefers to speak in Spanish. He's saying that they did hand this to you.
They showed us. They didn't give it to us.
Where did you get this?
That was mailed to me.
Okay, this was mailed to you. All right.
That was the last mail at 210.
What size envelope?
Dated.
Do you remember?
It was 210 and 27 on it, or 26.
Do you remember, was it a big envelope, a regular little envelope, what?
I don't know. It was with...
Because it better have been a big envelope, because there's only one fold on that document. And if they send it in a regular size envelope,
They
then that
did
was not
not,
mailed to you
I
in that
wouldn't
regular
make
size
that up.
envelope.
They didn't give that to me. That was mailed to
Sir,
me.
you just
And
heard
it
your
was,
case.
it wasn't a big envelope, yes, it was.
You're cutting out the chairman, I'm letting you. You just heard your case because your witness, Victor, just said that they handed it to you. And you're saying that they didn't hand it to you. He just said they handed it to you. And he works for you. I'm sure he's in a very uncomfortable position saying something that does not concur with what you're saying.
It's not true. We didn't get it. I swear to you, I'll swear in the Bible. We weren't able to get it. She didn't want to give it to us. She showed us. She handed it to us, yeah. And we looked at it. Victor, she didn't give it to take home.
All right. Okay.
I have no reason to lie about it. I mean,
Look,
they just
I'm
won't
not
give it to
saying
us.
that you're lying.
Mr. Chair, was that this year or last year he's referring to that? They got that last year or this year?
This document has the February 1st, 2010 date. So is this document referring to this year's problems or last year?
I swear to you, that was mailed to me, and it was probably in a big
I'm not
envelope.
asking you that anymore.
I have other paperwork here the same size.
Okay. All right.
Mr. Chair.
Go ahead.
Just indulge me for a moment. You went down to the fire department in Van Nuys, to the inspection division. When did you go down there?
God, I don't remember. It was last year.
Last year you went down there.
It
Why
was
didn't you
near
go to...
the end of 209, because
Okay,
we went
you-
down there to find out.
You went last, so that's not for this. That was for a previous
Yeah,
situation. So,
that
Mr.
was
Chair,
for 209.
the gentleman went to the counter for the fire inspection last year. It wasn't this year. Why didn't you go to the hearing that was scheduled May 11th for
I
this
wasn't home.
particular?
I travel. I can't be home all the time.
But were you noticed?
Pardon?
Did you receive the notice that there was going to be a hearing in May of...
But it was too
Last-
late.
Sir, you're not answering the
Yes, I
question.
received it. I
You
have
received the notice.
Yeah, in fact, I think you have it.
Okay,
I gave you one of them.
you received the notice, but you weren't in town, is what you're saying.
I wasn't there in May.
Okay.
Did you ask to have it continued or to schedule another date for the hearing?
No, that's why we...
Or did you just disregard it?
Very confusing.
No, it's not confusing, sir. You were noticed to come down if you wanted to go to a hearing on May 11th. If you couldn't make that date, May 11th, you could have rescheduled to another date. Did you ever do that to
No.
notify him? So you just disregarded?
I didn't know that, and that's why I'm here now. I
Okay.
realize we could
Okay.
be here now. That's
All
why
right.
I'm here.
Thank you.
I spend a lot of time in China, months.
Okay,
I'm not
got it.
home. I have a business.
Got it. Got it.
But these guys take care of my house, and they do a wonderful job.
Yes.
And that again, that area that they're talking about is completely refurbished. I mean,
Okay. Thank you, sir. Thank you.
we
Is
have,
there any other recommendation from the committee other than the recommendation of the department? It appears that the total assessment is $400 for the cost of clearance, administrative fee of $1,026 for a total of $1,426. Is there any recommendation from the committee other than that? Okay. Seeing and hearing none, I move that we concur with the department for the total assessment of $1,426.
Second.
Second, okay. So the vote is aye from the members. Okay, it's unanimous. Any noes? No noes. The total assessment, sir, is $1,426. Thank you. Gracias, Señor Victor. Okay, next we have Levon, sure, there you go, thank you. Levon Tabalakian.
Did not have an APN number from Mr.
Can you show them the document so that we can see what page we're on, sir? You sit down, please. You can have the seat. Which one do you use, Levon? You are? Okay. And you're the owner of record?
No, my father.
You're the owner of record? Okay. Page number?
276. 276.
Let them know, I guess. What page?
276.
276. Okay, proceed.
Yeah, so we had the hearing, I guess, on May 21st.
I'm sorry, state your name for the record again?
Levon Tabalakian?
And you're the son of the property owner of record?
Correct, Misal
Okay.
Tabalakian.
All right.
So we had our hearing scheduled for May 21st, which my friend and myself appeared on behalf of my father. So at that hearing, we discussed with the hearing officer and Inspector Gooday, which inspected our property, regarding a piece of land that's adjacent to our property, neither in front of or in back of, adjacent on the side. A parcel of land that they somehow figured belonged to us. According to the Zymus map that I presented to you, which I'm assuming the fire department uses the same maps, correct?
Yes, the department uses Zymus, correct?
Correct, yes.
Okay.
Both the hearing officer and the inspector at the time agreed with me that about 90% of the work that was conducted off the parcel of land that belongs to us, on the property that's to the right, if you're to look at it the way you are, to the right of the property, outside of the blue lines. So they said they would assess it, they would take into consideration what was presented to them, and we received their assessment of the hearing. But after the hearing was done, they came out after us, and they said that since they did agree with me that most of the work was conducted off our property, their advice to me was, why don't you go ahead, fence that property off, and make it priority of your own property. But I went and asked them, I can't do that legally. I need legal documentation in order for that to be an easement on my existing property. So I'm here to contend either if the council will allow us, I can't think of one.
Go ahead.
Either if that property could somehow legally be done as an easement on our existing property, or if we're still responsible for that property regardless of it not being on our property. Because according, even in the letter that was mailed to us, to, I guess, the Municipal Code Section 5721, quote, the cost of removal of other elimination or abatement of a nuisance from in front of or on a parcel of land shall constitute a special assessment against that parcel. But as you can see, most of the property, most of the cleaning that was done was neither in front of or on our property.
Okay, got it. Okay, apparently the issue at hand right here, this question of the department, is adjacent property. It happens to be adjacent to this particular property owner. Are we assessing them for the cleanup of the adjacent property that doesn't belong to them, or what's going on here?
We shouldn't be assessing him for any property that doesn't belong to him. That's what is confusing to me. And I just, my first time reviewing his protest in regards to what he is saying. Now, are you saying you did not receive any of the notices of noncompliance? So you didn't think you had any problem on your property at all?
When we received the notice, we received them after we got back. We were out of the country with family. We got back September 8th or 9th. And when I got back, I received the notices. But at that time, either the cleaning had been performed or was about to be performed. So until I was able to get all my stuff together, it was already too late. It had already been done. So what I had told the hearing officer and the inspector present was, if we were going to be held responsible for a property that was not, for cleaning that was not performed on our property, we would like to have an easement done in regards to, for us to know that that piece of land, that sliver of land right next to our property belongs to us, for us to take care of it. If it does not, like any other normal human being who's cognizant, will not take care of another person's property.
Okay. Got it. And as you heard earlier, even when somebody tries to do something nice to somebody else's property, there's still consequences, perhaps. Department?
Yeah, and that's true, and that's why I'm trying to get a further idea of what actually took place, because he should not be assessed for anything that's not his.
Okay. Well, while you're looking at that, I have a question for you, I guess. You're speaking on behalf of the property owners, your parents, your father. So you do contend that, unfortunately, even though you got notice, that there perhaps was some responsibility on your property?
Well, not on our property, adjacent.
Okay, I'm getting to my question. Was any of the clearance a requirement of your property, on your portion of the property?
None whatsoever.
Okay. What kind of maintenance do you have tip on your property ongoing?
To tip?
tip to tip. What I mean is on your property, your property.
We have a gardener.
You have a gardener.
Right.
And as far as, are you willing to contend to this committee that your gardener handles all the property? You don't have like a little junk corner with a bunch of flammables or anything like that? He keeps it nice,
Everything.
the entire thing,
Within the property line.
within your property?
He takes care of it.
Can I say something?
You stated that you're out of the country, returned September 8th or 9th. So when you're out of the country, how long are you out of the country?
Depends on business, anywhere from like a few weeks to 3-4 months.
So who pays the bills, the water and power and other bills?
It's all like through prepaid through my account and whatnot.
Is that Mr. Richard Herbeck?
That's the liaison for the property. If we're not there, he's the liaison to either myself or my father. And so indicating if there's any notices that need to be taken care of or any problems, they get in contact with me, right, whether via email, fax, phone call, whatnot.
So why wouldn't, you're saying you never got noticed?
Well, I received the notices once I got back in my mail at the house, which is separate from the process being contended.
Okay.
Well, the address, you live on the Glendale address?
Correct.
So when you're out of the country, who's at that location?
No.
So that's vacant?
That's vacant.
Okay.
But anything regarding the property itself is one of my tenants, which is Mr. Halbeck.
Property manager?
Not quite property manager,
Okay,
but like
but
liaison.
somebody manages the actual property in
But so
question.
when you're out of the country, then no one is picking up the mail?
Now, another question is, I overheard...
Hold on, I do apologize. We need to have the quorum present for these particular deliberations, for this hearing. Ms. Perry had to step out for a few minutes, so what we're going to have to do for legality purposes, we will recess this meeting for 15 minutes, perhaps give people a chance to go to the bathroom, maybe go downstairs, grab a candy bar or something, and then we will commence the process at exactly 12:30.
Sorry?
Okay?
Recess till 12.
So the hearing is still in effect, although we're recessing it for 15 minutes until 12:30, and then we will get back to this case and then continue. Off the record, I mean...
You're off the record, yeah.
good.
Thank you very much. Until we have a quorum, if Levon and his father can come back up so we can resume the discussions on this particular appeal. But I'm not going to hear from you until we get Ms. Perry here. But I just wanted to announce to everyone, we are unfortunately going to have to adjourn at 1 o'clock. So it appears that very few cases will be today. We cannot reconvene until Ms. Perry gets here because we need to have a quorum. And so after the people who are sitting before me, it appears that we perhaps will only have enough time to hear from Lori Harris and Noah Ornstein.
They are on the same property.
Okay, that is the same property. And being that it's 10 minutes to 1, perhaps with 2-3 minutes of latitude beyond that, everybody else, we are going to put over those appeal matters until next Monday at 9:30 in this committee hearing room. You can shake your heads all you want. All I can do is apologize. We are only human beings. As you can see, we're trying to be fair. We're allowing people to explain their interpretation of what's going on, etc. But what we could do, we could leave it to exactly 2 minutes and cut people off and not have really give them an opportunity to really say what they have to say. We could do that, and then we could all be happy, and we could have gotten this done. There were 20 cards, 2 minutes apiece. That's 40 minutes plus some latitude from. We could have got this done in an hour. So you can either appreciate the fact that we're acting like human beings and we're actually listening to what people have to say, or we could just read our notes, really not listen to what you have to say, predetermine what we have as an outcome, and just go ahead and make decisions without hearing you. So, if you would like to be heard and respected beyond the people that I announced today, again, all I can do right now is apologize that we did not get through all of the cards today. We would have liked to. So therefore, everybody else who filled out a card, we will reconvene this meeting, this hearing of this committee next Monday at 9:30, and we will hear all of your protests next Monday at 9:30. Again, I apologize. We took a little bit longer than expected. We have to maintain a quorum, and we're not going to be able to maintain a quorum after 1 o'clock today. So, rather than have you wait till 1 o'clock, I strongly advise that you're welcome to stay and listen to the other deliberations, but we're not going to be able to hear yours until next Monday at 9:30. Okay? We have to wait for Ms. Perry so that we can continue the official discussion on these matters.
Mr. Chair, we're supposed to reconvene at 12:30. It's now 10 minutes to 1, 20 minutes past. Can we get an estimated time of arrival by Ms. Perry since we're going to conclude at 1 o'clock?
We'll have my staff person call their office again and remind them that we're waiting for Ms. Perry. Okay, all right. If you could step aside for a second. We've just been noticed by one of our city attorneys that we can call up Lori Harris, that looks like a H-A-R-N, Lori Harris and Noah Ornstein. And the reason why we can hear your case is because apparently perhaps it can be handled in a manner in which we do not need a quorum. So let us begin in a couple of seconds with the department. Yes.
I'm Janet Jackson. I've also, at the break, had Deputy City Attorney. I had an opportunity to talk to this appellant, verify some information. There does appear to be a problem with the address that the department is willing to acknowledge, in which case the department can handle this matter without the necessity of a vote from this committee.
Okay. So could you clarify for this committee from the department how you would recommend that you're going to handle this?
We will review our documentation on as regards to the address of record that was on file for the appellant here. As regarding to what their mailing address, it appears as though there was an issue with the property owner being properly served.
What page, Captain Knight?
274.
274, you said?
Yes, 274. This matter could have probably been taken care of if we'd have met at the hearing. The appellant was unable or failed to appear at the hearing, and so we are here now, and this information is just being brought to our
Okay, so between now and next Monday, you will work with the appellates, and then you will let them know what your recommendation is going to be of the committee, and if your recommendation is satisfactory to them, then perhaps there's no need for them to come next Monday, correct?
That is correct.
I'd like to be
Yes.
heard for just a minute.
Sure, absolutely.
Thank you. I live in Santa Barbara, and it's a hardship for me to come down
Sure.
for these hearings, and so I provided this morning copies of the correspondence with the incorrect address,
Okay.
as well as a chronology of events that I'd like to have be part of this record.
Absolutely,
And
it is.
we also looked at what this body has done in cases of due process violations. And in the Koshman Construction Corporation case, which was decided on May 17th by this body, because the appellant did not receive proper notice, the administrative fee was vacated. And that's the relief that we're seeking here. Because we did not get notice, we accept that the property was cleared and we'll pay the fees for that, but we would like the administrative fee to be rescinded as it was done in this other case just last May.
Okay, being that we do not have a quorum, the committee is not going to consider your request because we will be violating the process. However, you can administratively work with the department on that. And like I said, if it comes to your satisfaction, then perhaps you won't have to be inconvenienced and appear next week. So between now and next Monday, make sure that you communicate with the department. It appears the department is more than happy to clarify. And then if that's the case, then you'll be happy and everything will be in order.
Well, thank you.
Okay.
Thank you very much. Thank you very
Okay,
much.
thank you.
Thank you.
All right. Okay. Mr. Levon? Sepelekian. And on page 276, right? Right next to the last one. Okay. So, this one's page 276?
We have a quorum again?
Yes, thank you very much. We do have a quorum. We have 3 members present in this committee, and we will be adjourning shortly after 1 o'clock, which is in just a few minutes. So it appears that this is the last case that we're going to be able to constructively handle today. Everybody else, if you're here to hear your hearing case, we will reconvene next Monday at 9:30. Again, my apologies, but that's the way it's going to be. Okay. Hold on, to the department. On this particular case, is it going to be possible for the department to assess whether or not there was work done on this particular property, or if it was truly the adjacent property that does not belong to these particular owners who have been noticed and charged?
At this time, I'd have to go back and review it, so we'll have to continue this the next week.
Okay, all right. So you understand what the department is going to do? What they're going to do is they've heard what you just said. The committee has heard what you have said. It appears that perhaps it is a matter of mistaken identity as to who should have been noticed for the adjacent property that was in fact cleaned. And it appears that unless the department tells us that a portion of your property was cleaned as well, then it might complicate matters. But if the fact of the matter is the work that was done was truly off-site from your property, then it appears that you're going to have a good resolution to your situation. Okay, so does the department understand? There's 2 things we want to clarify. First of all, which property or properties were actually cleaned?
Yes.
And that being the case, was one of those properties this particular property?
Yes.
Okay. And do you have a way to communicate with the department? between now and Monday?
We're going to establish that right now.
Okay. All right, they're going to give you their information right now. Okay, that being the case, yes, as I've noticed to all the other people, thank you very much. We will see you next Monday, and you should hope and expect that we go very diligently and quickly, but more importantly, that we handle your matters in a fair and appropriate manner. No, we probably have at least a dozen. We had 19. No, not yet. We have general public, you can go. General public comment, which is not a voting item. We have general public comment. I think we had one card for general public comment, which is Dr. Clyde Williams. Dr. Clyde Williams going once. Dr. Clyde Williams going twice. Okay, yeah, I saw. I just want to make sure he understands that we called him. Okay. Thank you. So that was the only general public comment. This Public Safety Committee of the City Council of Los Angeles. Again, once again, I will say I'm sorry that we did not get to all of the items. This committee